KTN News.
Welcome back to Kivumbi 2017. We continue dwelling on that presidential petition whose submissions ended yesterday at the Supreme Court, with the 7 judges now retreating to draft the final ruling, which will be given on a Friday. In the studio with me, I have a lady and 2 gentlemen who are legal experts helping us analyze the proceedings of the court. Now, gentlemen, the last order of business yesterday was a discussion of that report with regard to an audit of the IEBC servers. It was a heated debate, but there was a lot of excitement, first of all, when the court allowed access to these servers. Many saying, especially from the NASA side, that this is our time to roast the IEBC and the Jubilee Party. Maybe we can begin with you, Dr. Mukwana. I don't know if you've gone through this report, maybe some of the particulars. What did you make of it?
Thanks, Michelle. I must confess that we are a bit disadvantaged, I think the 3 of us. I don't know about you, but we are a bit disadvantaged because we've not had a chance to peruse the report as submitted by the registrar. We have that bit of that disadvantage.
Right.
However, we have the advantage of deducing commonalities between what the petitioner, Honorable Raila's counsels were saying and what Counsel Ngatia and Honorable Counsel Muite were saying, and therefore there are some common areas we can deduce that came out of the report, and I'm sure my colleagues would agree. The first thing that came out clearly is what you've already mentioned, that there were attempts to deny them access. That was eventually resolved. The forms from the verification. A number of forms, we do not know the number. Honorable Rengo says 58. Because we don't have the report, we are not in a position to quantify. But that was admitted on the other end, that indeed there were a number of forms 34A that had problems. What was the nature of problems? Number one, some of them lacked serialization.
Right.
Now, serialization is so key because that is on what basis you can say that then the forms were supposed to be 200, they ended up being 500. So there was no serialization. And that was admitted actually by the defendants.
Well, maybe just on that same point, Paul Muite says there is no rule, there is nowhere in the Constitution that provides that security features are a key requirement of these documents.
I must sympathize for Honorable Paul Muite, because there was also another time when he was asked to explain why they were not granting access, and as Wakili has said here, he had to resort to the explanation that the other side was still asleep. Also, there was he also said, while trying to explain the firewall, for us who are not IT experts, the firewall, and he compared with the Mutego Wapanya in City Park. So I must understand Honorable Paul Muite, because sometimes in lawyering, such moments are not so funny. The truth, yes, they're not so funny, especially when you're pushed on the back wall. Those requirements, whatever it says, were not necessary. The judges, from the way they reacted, didn't take it very kindly. They asked, for example, when there was the issue of the forms differing, because the forms that were printed in Dubai from Al Ghurair printers had specific features. It makes common sense, forget about the law. It makes common sense. It makes the independent election commission to be credible, to be trustworthy, and inspires confidence on the voters that justice was done if the features that were declared are there. So that defense really, as I said, I sympathize with Honorable Muite. There were no serializations in some forms. How many we do not know, because we don't have access to the report. Number two, some forms did not have the security watermarks. Others were not signed. In some places, the figures were not adding up. Now, finally, without taking a lot of time, in Mombasa, I think it was Jomvu, Nyali, where it was so clear that the forms were not signed, among other deficiencies, and Counsel Ngatia's explanation was that, look, it was an error. That error was admitted. Two, that the petitioner, Honorable Raila, actually got more votes in that area. I do not know what that would help by saying, after all, the petitioner won. Maybe what he's trying to say is that how could we have stolen or how could we have acted manifestly fraudulently if the end result was that the petitioner won? And even if we were to discard that, then it is still the petitioner who loses. But the point is this, Michelle. Errors are human. But when they become a bit rampant, when they become a bit too common, then it introduces the thought that could this have been deliberate?
All right. And of course, I have a bit of a snippet here of the report by the petitioner with regard to that particular access to the IBC servers. So one of the issues that they've listed here is that the access control list to the system provided for only 341 users between the 6th and the 22nd of August. But according to what they witnessed, there was about 3,300 failed login attempts and 3,800 successful login attempts. They also say that access was granted to strangers who were not identified by role, were not defined by any access lists, and among these were vendors, anonymous users using Gmail accounts, and administration staff were noted to be logging into the KIEMS system between the 8th of August and the 22nd of August. Now, of course, this is with regard to NASA's question as to whether somebody actually accessed the IBC servers. Let's come to you, Jemima. This is part of that audit report. What do you make of it?
For me, of course, it's disturbing if that are the findings. And as I said before, the Constitution is very clear that the electronic transmission system, whichever way it is adopted, must be verifiable, transparent. So all these things will weigh into the decision of the, finally when the judges sit, they will have to consider what is the implication of all this. Because the integrity of the process is just as important as the outcome. So if there is no integrity in the way you operate, you arrive at the results, the numbers don't matter anymore.
And clearly then there's a lot to consider.
Those are issues which the court will consider, look at the magnitude, are they enough to reduce or eliminate any credibility in the process. Those are the issues, as again, we must consider that mere irregularities alone are not sufficient enough to nullify an election. But the court will look at the integrity of the process. Was it so bad that whatever the outcome was not credible?
Very briefly
before you go to my colleague, she's right that mere errors may not warrant much. But let's look at the nature. In one claim in that report, again, we must be respectful to the defendants because we do not have the original report of them. So that we must certify. But there is one very alarming one. An email, vkimeli@ibc.or.ke from Sotik in Bomet was allowed to get into the system and upload software applications. Now, then there are other Gmail accounts, non-partners to the system, who are allowed access. If this be true, and if this be contained in the report of the registrar, this could be fatal to the defendant's case. Because the anchor, as I've said, the anchor of this NASA claim has been that the mess occurred at the server. And then, just before I give him a chance, what messes it more for the opposition is this, that there is a report saying in this that they were denied what you call certificates of the certificates of tests, showing that this system had actually been tested and there could be no penetration. That is under the elections regulations regarding technology. It is a requirement that there must be a certificate. So if this certificate is not produced in court, that could just lend credibility to the hacking claims of NASA. Thank you.
Yes, Collins, go ahead.
Yes, what I wanted to say first, I'd like to say I'm quite impressed with his understanding of the IT and the certificates and everything. That is quite something that we have talked about for the bar. We need to also now catch up going forward. But Michelle, what I wanted to say is that elections in Kenya is not a one-day thing. Elections, immediately after all this will be wrapped up, the IEBC will start preparing for the next general election. So they have quite some time to build and establish their things. Now, part of the evidence when it comes to the servers things that the petitioners relied on was the video of the late Msando, where he talked of the system, how it's watertight and can't be hacked. And there's something he said that where they even stopped the video at, which he said anything that will be transmitted by the KM's kit to the server, nobody will have the power to the ability to remove the document or edit. And you remember the Mandera, the one that was the polling station in Mandera, where one of the POs uploaded on an exercise book the numbers of the presidential candidates. And in a way, that document found its way out of the system. So these are some of the credibility issues that are being questioned. Maybe just to talk on the report on the manual forms. Now, these security features were not features that were the petitioners came up with. These are things that the first and second respondents came up with. They said, look, we are going to print these forms, and these forms will bear these certain security features. Now, it was quite interesting in that there were 34 Bs that were not signed. But counsel for the first and second respondent, senior counsel Paul Bito, said, look, yes, we admit they have not been signed, but they bear all the security features. So you see, even the CJ was perplexed. What are you trying to say? So that to me was also something that caught them off the foot. But more importantly, Michelle, apart from the judgment on the case, something that I'm also very interested in is actions that the judges will take on these election officers. Because for me, 34 Bs are forms that were generated by returning officers. Returning officers are staff of the IEBC. These are permanent staff. These are not people who are appointed on temporary basis. So some of these mistakes, to me, I cannot term them to be clerical, bearing the ruling in the Maina Kiai case that presidential elections are held at constituency level.
All right. Lady and gentlemen, we don't have much time. Let's very briefly take a look at your expectations, because as we speak, the 7 judges will be retreating to draft that ruling that will really be determining the country's fate on Friday, and I beg your pardon, how we'll proceed going forward. Dr. Mukone, again, the issue of that Solomonic wisdom has been brought in this ruling, with many saying maybe the court, should consider a ruling that is not a one wins all, one man loses all. What are you expecting on Friday?
Michelle, as an advocate of the High Court of Kenya, I expect that the judges will be led by the evidence adduced and the facts. Whether that will lead to a win-win or a lose-lose situation is something that cannot be predetermined at this stage. For us, first as an advocate, I must commend that the judges have an uphill task, because the volumes of the evidence that has been adduced is huge. But again, they have displayed and demonstrated that they are equal to the task. So my expectation is, come Friday, time we do not know, but it will have to be before midnight. Come Friday, the decision that the judges will come with, it is my expectation that it will be a decision that all Kenyans will live with. Going by the way they have handled the proceedings, and barring any other surprises in their manner of handling the rest, we expect that come Friday before midnight, inshallah, we will have a decision which Kenyans will live with. And finally, it is important that as a country, we understand that we must go beyond elections. And if the court delivers a decision that is sound, based on what the facts are and what the evidence is, we all must accept and say, let's wait for another day.
All right.
It's one country, it's one people, and we must remain so.
And it's one Kenya. Jemima, your closing comments.
Thank you very much. I think for me, my expectation would be that the will of the voter will be upheld. And that is a cardinal principle even in election petition. As much as there are irregularities and everything, the court will weigh the evidence and clearly show us whether the process was credible and whether integrity was upheld, and that whether the results are acceptable. And most important for me, I think as a voter and as a Kenyan, I would appeal to all of us to accept the decision when it comes, because this is the final court. And of course, we are happy with the process so far. It appears to be fair. And if the final judgment comes out and decides that we do another election, Kenyans should be ready to accept that. It will be good for us as a country that we should be in a position to accept that an election petition for the presidency can be nullified by the courts. That would be very good for us as a country, if that happens.
You know, it is, of course, something
if
that
it
Kenya
does
has never
not
seen.
happen, then, and the decision is also sound in law, and the courts give a clear path as to how they arrived at the decision, then also we shouldn't accept that, because that would be the decision by the highest court of the land, and it will be what we Kenyans expect.
All right, and of course the question has been, if the court decides we should have another election, what is to guarantee that we will not be back in court with the same issues of irregularities that are being announced? But that is a conversation for another day. Dr.
Yes,
Mukwana, I see you wanting to speak. Let me give Collins his closing comments.
Yeah, I'm sure you wanted to talk of the constitutional crisis that may arise in that the credibility of the commission will have been put to question. But already we've seen the political pressure that is in this case. The judges have been already clearly told that this time round they expect that each and every judge shall come up with his or her own judgment. And on that note, I also wish quick recovery to Justice Ibrahim, who could not attend yesterday because he had fell ill. So he wish him quick recovery even as they continue to try come up with a judgment. So what I expect is a judgment that, as she has said, will have both parties really brought strong cases. The petitioner brought their case, the respondent equally rebutted in strong measure. So it's a close call, and really it's now up to the judges to come up with a judgment. So we'll wait and see.
All right, ladies and gentlemen, we'll be back here on Saturday, I believe, as we begin looking at the decision of the Supreme Court. But thank you very much for joining us on the early morning edition of Kivumbi 2017. Lawyers Collins Mango, Jemima Kelly, and Dr.